Welcome back. We're now in Module 3, Week 3 of Legal Evolution of America's Three Major Leagues. Here's our update script. The MLB antitrust exemption. This will be the one module where we'll ask for the one and only group writing assignment. So we're going to try to prompt how far should this antitrust exemption extend? Should only Congress be able to repeal it? If it gets appealed to the Supreme Court, could the Supreme Court reverse itself, in effect, stare decisis, the baseball trilogy leading up to Flood v. Kuhn, or are they bound by that precedent? Judge Kaczynski's case is going to be particularly instructive on the territorial relocation antitrust exemption, where he says the business of baseball encompasses the entirety of the business of baseball, and the antitrust exemption should be quite expansively interpreted that way. That went to Supreme Court, they denied cert, so it gives us something to think about. Miranda talks about minor league players, antitrust, it's all in the book. No, they don't have antitrust standing because they're at the core of business baseball. We'll see in Chapter 3, dealing with third parties, get like Salvino, you'll see we'll get antitrust scrutiny. That's all that means. It survives a motion. American Needle, same way it survives a motion to dismiss, it gets antitrust scrutiny. But otherwise, the business baseball doesn't even allow for antitrust scrutiny, at least as things stand now, relating almost anything that relates to the core, like umpires, core business baseball. Certainly, in the Flood Act, we'll deal with that in some detail when we get there. Did it mean to exempt from antitrust scrutiny everything else except free agency for the 40-man roster, as it were? Or did it mean to leave that subject to, like Piazza and Terendi, antitrust scrutiny? Judge Scheinlin certainly says in the case that you'll read about, the Lauman-Garber case that deals with media and territorial media rights, certainly says, no, I think actually it's the reserve clause and only the reserve clause that you get antitrust scrutiny. So that's a little bit preview, but that's how we lead to challenges to the antitrust exemption, right? This was contraction, not renewed. For minor league teams lost their affiliation. They call it an unlawful boycott. This is Jim Quinn, who's been a frequent guest for us at HLS. They claim that by losing their affiliation, there was a violation of the antitrust monopolization, both Section 1 and Section 2 of the Antitrust Act. We'll look at that. There's also contractual cases, which we really aren't going to deal with, saying, oh, you promised, promissory estoppel kinds of cases. But on the antitrust point, Jim Quinn, on behalf of these teams, wants an immediate appeal to the Supreme Court to have them reconsider Flood v. Kuhn, Aaron. So what do you think? Or should it be left? Must it be left to the DOJ and the Senate Judiciary Committee?
Yeah, that's been the argument that's been made throughout history, right? Ever since Toulson and Flood v. Kuhn, is that this isn't for the Supreme Court to decide. This is for Congress to decide. And you've seen pieces of legislation be introduced, multiple times and haven't really gone anywhere on this issue. And so, in my opinion, it looks like it is for the Supreme Court to decide, and I hope they do take action on it here. But yeah, I think ultimately kind of go back to the running theme throughout this update and throughout Chapter 3 is what really is the scope of that antitrust exemption. And here we're talking about contraction of minor league baseball teams. And as you'll see when we get into the Senate Judiciary Committee's inquiries, you'll see both sides of the arguments for why, the antitrust exemption, makes sense when you're talking about specifically minor league baseball, and why it doesn't make sense when you're talking about minor league baseball. I think, looking at Miranda and other cases regarding minor league baseball, which is what a lot of this update focuses on. You see that it falls kind of, most people see it falling squarely within the business of baseball. And I think a lot of these methods here that you see, the lawsuits, the inquiries, and legislation are trying to figure out a way to get some of these things exempt from the antitrust exemption.
And query in the Sports Broadcasting Act, which we deal with here, why does baseball need an exemption to be able to monopolize the broadcast of its games with limited exceptions for blackouts? Query, if they're exempt, then why did they need to be included in the Sports Broadcasting Act as being exempt from antitrust scrutiny in that area? So those are the kinds, and Silverman getting way ahead of ourselves, is a case that says, no, you will be subject to antitrust scrutiny when you're at the bargaining table. You cannot engage in unfair labor practice when you're at the bargaining table. And that will be a good bridge to Chapter 4. And these footnotes are terrific. They really explain what the contraction involved. They really explain what happened. And the question is antitrust scrutiny at all or not? And yeah, these footnotes are terrific. So those who want to take a deeper dive, I would commend those wonderful footnotes to you.
The one thing I'd add to Press Carfagna is, you touched on it earlier, is when we're talking about procedurally the antitrust exemption, right? When it applies, there's no antitrust analysis. MLB is also in the case as to if the MLB antitrust exemption did not apply, this is how an antitrust case would look against us in providing, going down that path, which you'll see if, an antitrust analysis laid out throughout the book, but you'll see how they would, argue a Section 1 and 2 antitrust case against them.
Yeah, we have an antitrust flow chart for when we get to that. And we're not asking you to be antitrust or labor experts, just enough to work for a team or a league, and understand what goes to grievance, what goes to court, and what can be kept out of court, and how and why. Almost thinking like a litigator, a pre-litigation mindset to advise a Jeff Pash. And this week, we're lucky to have Matt Nussbaum from the MLBPA, who's been a frequent guest for us. And Alexander, we have a partner from Proskauer coming. Maybe just want to describe who he is and how he'll try to explain the antitrust exception to us. Alexander.
Oh yeah, for sure. Brad Ruskin, he's a co-chair of the sports group at Proskauer, and he's on the litigation side. And we mentioned in week 1, I'm blanking, Jeff Kessler, who kind of does all the NFLPA litigation. Brad Ruskin's kind of the foil of that. He does a lot of the antitrust stuff on the league sides. And so he's pretty much an expert on MLB antitrust, huge MLB fan in general. So he should be super helpful in kind of fleshing this out and putting in kind of practical terms for you to use.
And Matt Nussbaum always sponsors a placement. Will be the other side of that argument, and that gets to unionization. Is that next? Unionization of the minor leaguers, Aaron? Is that next? Advocates.
Yeah, we talked a little bit about DOJ and Senate Judiciary Committee's involvement. It's a little bit different, and that the DOJ is kind of a statement of interest on this above contraction case, but the Senate Judiciary Committee actually did submit inquiries to MLB and a group that advocates for minor leaguers, asking for their input on how they think the MLB antitrust exemption should relate to minor league baseball. And so that's kind of, they're collecting, they already received responses from both sides now and are evaluating. And then the only piece I'd touch on before MLB unionization effort is legislation introduced by Bernie Sanders to abrogate the MLB antitrust exemption. That's still in committee and has not gone anywhere. And I mentioned a little bit before, there's been legislation before introduced with the same intent that hasn't really gone anywhere. So I don't know if this can be considered very promising, but it's something to note.
Yeah, that's really well said. And I think just let's go up a little bit. The Flood Act, what it would mean to say treat minor leaguers the same way. So the Flood Act says those players who are major leaguers, the 40-man roster is shorthand for that, have standing to bring an antitrust cause of action. That's the minimalist reading. It says at least that. The rest of the business of baseball, you could say is exempt, or you could say it's subject to antitrust scrutiny. That's a whole part of this. But by saying we want the Minor League Flood Act, that would free them up to be able to sue over restraint of trade. Let's just call it that, okay? Now, as soon as the major leaguers collectively bargained with the Major League Players Association, negotiated with the owners of the major league teams, then that standing to sue goes away, okay? That's because it's collectively bargained, and that's after it's collectively bargained, free agency and how many years before arbitration eligible and all that stuff. Once it's collectively bargained, any grievance, as we've said, would have to go to arbitration. And the right to sue the league has been taken away from the major leaguers through collective bargaining. Okay, just want to make that finer point. But MILB does not have the benefit of a union yet. They have no standing. Arguably up till now, they had to sign a uniform player contract. It was take it or leave it. And if you chose not to, you were out of the game. You had to play independent ball instead of affiliated ball. Fewer spots in affiliated ball now due to contraction. So the unionization effort, and Matt will talk about this. We can see what it would take for them to be unionized. And the point would be once they're unionized, then they would be protected by what we're going to learn is a non-statutory labor exemption, which means that which a union negotiates with ownership, with management, with team owners and leagues is through the non-statutory labor exemption immune from antitrust scrutiny. That's reading ahead to chapter 4.
Yeah, and so just to clarify, because you said that really well, Professor Carfagna, and then just to clarify, major league players, right, have standing to sue under antitrust laws under the Curt Flood Act. However, because they have a collective bargaining agreement with Major League Baseball, they're subject to the non-statutory labor exemption. Minor leaguers have neither of those rights currently. They have no rights to sue under the Curt Flood Act, nor are they represented by a collective bargaining unit with a collective bargaining agreement with Major and Minor League Baseball. So they have neither of those, and that's why you see unionization effort, right, which would subject them to the non-statutory labor exemption, or we're talking about separate lawsuits, the Sene lawsuit, which is a Fair Labor Standards Act and minimum wage lawsuit, not an antitrust violation or not an antitrust lawsuit.
Right, and that's a huge settlement that just happened. We've had Attorney Sene, a former minor league player, on panels in the past. He finally paid her to write 185 million reasons for why he waited almost 10 years to get a settlement. And again, this distinguished, it's a Fair Labor Standards Act case, minimum wage. They thought they had dodged this bullet. MLB had through the Save American Pastimes Act. That's footnote 12. It denied protection to minor leaguers, but it does not apply retroactively, right? And it doesn't bar state law claims concerning minimum wage and overtime pay. So based on what Judge Spiro has said here, the teams are going to have to comply with state FLSA requirements on the other side of the settlement, and the protection for the teams in the league under the Save American Pastimes Act is still alive and well. And in fact, minor league teams are going to have, wherever they play, wherever they go, are going to have to be careful about complying with state minimum wage and overtime pay. Go ahead. That was $185 million settlement, ultimately for this longstanding case.
Yeah, that's the needle to thread, Professor Carfagna. What you just did is that Save America's Pastime Act does not apply retroactively, applies proactively, but only to federal Fair Labor Standards Act claims, not state wage and overtime claims. So that's kind of the needle to thread there, and where we're going in the future.
Yeah, again, not antitrust, straight up,
right?
Fair Labor Standards Act. Watch this space. It could be $1 billion swing for the teams to have to comply. Will likely be because right now we'll learn minor leaguers are paid next to nothing until they get to double and triple A, and all they have is their guaranteed signing bonus. And after that, it's probably arguably below minimum wage for the hours they're essentially required to put in.
Yep.
Okay, and that brings us to the end of chapter 3. Quick updates. Otherwise, the scope of the antitrust exemption will be the real pivot point here, and how far should it extend? What does the business baseball mean? What does the Flood Act really mean beyond standing for players on the 40-man roster? Does it extend to franchise relocation? Does it expand to minor leaguers? Did they mean by not putting that into the act to exempt it from antitrust scrutiny, they, the congresspersons, or did they mean to leave it available for antitrust scrutiny in each of the other areas of the business of baseball? So I think this will be a good run-up for Module 3. We'll have great guests for week 3. And anything else to add as this preview? Aaron?
I think we hit it.
Alexander. Thank you very much. Thanks. We'll see you in class for week 3. We hope you get a chance to at least flip through this before we get together in class. It'll really help expedite your work on the group hypothetical. Thank you.